Hello, and welcome to Talking DV, a podcast that focuses on domestic violence and practical guidance on how to leave a relationship where your husband, wife, boyfriend, girlfriend, or whoever might be harming you. My name is Dean Hinton. I'm a licensed attorney in the state of Tennessee. For almost a decade, I've handled cases involving people whose partners have been physically, emotionally, and financially abusive to them. By providing practical guidance to you, my guest and I will hopefully help you escape harmful relationships. With me in the studio today is Rebecca Toca, an attorney in the Nashville Office of Legal Aid, to discuss orders of protection. We're going to start off by talking about excessive spanking cases, then we'll get into stalking and sexual assault, all within the context of orders of protection. Becky, I'm just going to start off with something really basic that I think is true. Don't go into a court expecting the order of protection to extend to the children in excessive spanking cases. Excessive spanking does not win the day usually, at least in my world. And my world is some of the rural counties around Nashville. Judges give parents a lot of leeway to spank. I'm going to say beat the hell out of spank their children. I don't necessarily. I'm going to just say this. I do not necessarily agree with that, but historically, judges seem to let. I'll give you a quick example. This was in Wilson County. A child was beaten 6 or 7, 8 times up and down the leg with a tree branch, left significant welts on the child. And 2 different judges said, yeah, that's excessive spanking, but don't spank the child again, but there's no OP or anything like that.
Correct. Same situation, and I covered Davidson and Williamson County, but just yesterday in Davidson County where there was spanking alleged and as a form of abuse to the children. And that's just another very common defense. Whenever a child is being, like you said, hit, beaten, prepare for that defense that I was disciplining my child. That was discipline. That was 100%, and it's just a difficult thing. You have to be able to prove that it was excessive, and even when you do prove that it was excessive, sometimes they will give that parent leeway because they'll say that is how some people discipline their children. So you have to be ready for that defense if it is a spanking situation or anything that could possibly be considered spanking. I will say one time I had where the party beat their child so badly he had internal injuries, and we had the medical records to show that, and we had the child was a teenager, so they were able to testify, and the judge did find that it was excessive and did grant the order of protection. But like I said, it was a teenager who could testify about what happened in detail. We had medical records that showed the internal injuries, and so the judge said that was too much and did grant the order of protection. Now, I will say, I think that if I didn't have all of that, if it's a younger child who cannot articulate what happened, if it is anything where you don't have anything to corroborate, like you mentioned, you had things to corroborate how bad the welts were and things, and sometimes they'll still call it discipline. So yes, it's just a defense that you have to be ready for. And I will say, they also want to see that, was that reported to DCS? Was that reported to Department of Children's Services? And what did they say? When you're talking about the child abuse, you have to be ready for the DCS questions and the discipline defense, that was discipline.
In my experience, too, DCS won't do much about excessive. I mean, they'll investigate it, but again, parents seem to be getting away with a lot as far as under the umbrella of spanking or discipline.
And like you said, maybe it's just that the order of protection, I really find that the order of protection, the way it's written here in Tennessee anyway, is designed for adult abuse. It's designed for intimate partner violence, stalking, or sexual abuse, those kinds of things. When you're starting to talk about the child abuse, while it can be used when there's child abuse, and obviously in some situations, like I said, it has been granted where you have corroboration and you can show what the child abuse was, it is not designed for some of these things that also are child abuse, but just are difficult to prove in a civil order of protection court, like excessive discipline or sometimes abuse of a very young child who cannot testify. That is very hard to prove, right? If you have a child that is not, and for maybe lay people, younger children, usually under the age of 9, I would say, are often not swearable. They are not capable of coming into court and telling the court that they understand the difference between a truth and a lie, and that they understand what the oath is that they're taking. So those children are not swearable. They're probably not going to be able to testify about what happened to them. So then how do you prove that this happened? Well, usually there is a hearsay exception for child abuse here in Tennessee where an adult can testify about what this child told them. Okay, so that gets their child's statement to the court. But if that person is, let's say, just common scenario, the mother of that child, and she comes in and testifies about what the child told her under that hearsay exception, but she has no corroboration, no photographs of injuries, no, abuse usually is not in a public place. There's not going to be a recording. Usually you don't have these things, child abuse kind of thing that's usually done when people are not watching, right? You have the mother coming in to testify about what the child told them. If you don't have any corroboration, then the other side's going to argue, well, she wants full custody. And how are you countering that defense? How are you countering that argument that you want full custody? You don't really we don't have a child we could put on the stand. We don't have anything to corroborate what happened. If there's nothing, like if there's no medical records or photographs of some severe injuries, then it's a hard thing to overcome. And judges don't want to, they hold the parental rights in such high regard that if that's what you have, it's just going to be it's almost impossible to prove in court. And so that's why this order of protection statute is probably not designed for that. It's not designed for the abuse of a young child, in my opinion. It's more designed for adult abuse, someone who can come in and testify about what happened. Of course, there's some exceptions to that, but there just might be a better vehicle for a child abuse case if you don't have certain corroboration to what happened, such as juvenile court, DCS reports, dependency and neglect actions, things like that.
And you mentioned the statute, and it's limiting. It's limiting as far as attorneys are concerned, because there's not this broad definition that you would think, I guess a layperson would think would fall under that, and I need an order of protection. And so the statute actually says this is the legal definition of abuse in the summer of 2025 in Tennessee. The first one is, under A, it's inflicting or attempting to inflict physical injury on an adult or minor by other than accidental means. So inflicting or attempting to inflict physical injury. The second one is placing an adult or minor in fear of physical harm or physical restraint. I probably see much more of the actual inflicting of physical injury than the attempting to, but okay. Anyway, it's there in the statute. Even placing someone in fear, but how are they placed in fear? It sort of becomes an issue.
And the placing in fear has to be reasonable. It has to be that it was placed in reasonable fear and that you were actually, it has to be, and to explain that, just they're making outlandish threats. That probably is not going to pass the day. But if they own a firearm and are threatening to shoot you, that might place you in reasonable fear, and that kind of thing. So
right. No, I had a case a while back in Sumner County where a gentleman, the husband, pointed a gun, and they were able to prove it. He was arrested, and they found the gun and so forth. So yes, she did get an order of protection. He placed her in fear by pointing a firearm at her. I guess chasing someone with a knife, something like that, would rise to the level of placing someone in fear. But I can't really think of too many more examples of where that would have occurred. I don't really know.
I would say just sometimes people say things and you can testify about what they say, but if someone is threatening you and you can record it on your phone and get that recording, that would be really great to play in court, one day if it comes to that, versus just you saying, oh, they told me this, they told me that. Obviously, sometimes you can't, and I get that, but if you have the option to try to record somebody who's threatening you, if they text message you something threatening, you could take screenshots and save that in a safe place. Those are sort of the main examples that come to mind.
The third part of the statute is if a person causes malicious damage to the personal property of the abused party. By the way, in the statute used to have injury to pets or harm to pets. That's taken out, but I guess it would fall under here. I guess pets would be considered personal property. But causing malicious damage to personal property. If a person wanted to go into court just on damage to personal property, I don't think that would carry the day. I'm just guessing. I don't really see that a lot. I mean, I do see damage to personal property, but it's usually in the context of other things happening, such as physical injuries.
Right. I've seen it here and there. I've seen one based on a wife, actually, who damaged her husband's immigration documents. And although I will say, I guess there was more to it in that I think she tried to cut off his clothing while still on his body. So,
okay.
While she didn't maybe hit him, she damaged his property and came at him with a pair of scissors. So that would place someone in fear of physical injury for sure. But
that's actually a good example.
So yes, it's possible, but yes, I would say that if you have the damage to property with something else, it's probably going to be stronger than just by itself.
And then there's financial abuse. I think we talked about that already. I don't really see in that. I see financial abuse a lot, but not as a standalone, so to speak.
Right.
And so if someone has been financially abused, according to the statute, which I don't really have a written definition here, but if you feel like you've been cut off from money and you want to go ask for an order of protection based on that, I don't really think many judges, at least in my area, would be persuaded by that.
Well, and I think the issue with it here is that it's very new. It's a very new update to the statute, so there's not any case law on it. I've done a little research on it. not a lot of case law on that since it was just recently added to the order of protection statute, but we'll see how it plays out. And that's the other thing you mentioned. Usually domestic violence cases have financial abuse and other abuse. It's very rare that it's in isolation, and so that's why I haven't seen one where it's in isolation yet. It's usually coupled with other things, physical abuse or fear of physical abuse. So
I don't want to get too deep into the weeds, but when it comes to something like that, judges hear a range of things, of harms to people. So over here, you might have someone who's bucking up, so to speak, chest to chest with their partner and the fist balled up like they're going to hurt them or hit them. And then over here, you have a broken eye socket or strangulation where I have a client going to be in court on Monday. The husband, he's in jail. He stabbed her multiple times. He's facing attempted murder. So judges hear things like that. Mm-hmm. And on the other hand, you have financial abuse. My husband, my spouse has cut me off from funds. I can't get money. I can't eat and so forth. The judge, at least in my areas, I kind of see them, and obviously I'm not the judge. I can't speak for them inclusively, but they probably just shrug and say, what else you got? I mean, maybe not to me or to the client, but just internally to themselves. It's almost like domestic violence in some ways sort of gets normalized in the sense that this is bad, but it's not that bad. But this is really bad, so you must react.
Right. You make a good point. Every judge is different. Judges are human, right? And they're listening to these cases pretty regularly. And so while I think that what I see is that sometimes you'll have a case that is presented to you and it technically is, abuse under the statute. Maybe it technically fits what it is. But then you get into court in front of a judge and the judge is hearing sort of they're going to hear from both sides. I mean, that's the thing. They're going to hear you, the victim's version, and then the other side has the right to question you, to attack your credibility, and then also say their kind of version of events, their defense. The victim was abused, obviously, when they're telling you kind of their side of things. The defendant or the respondent is going to have their version of events, and then a judge has to sort of make this decision, and sometimes the judges are swayed by the defense. It's hard to explain that to folks because, of course, yes, I believe you, I support you, I want you to get this order of protection. But when the defendant's going to come in there and say, I didn't do it that way, that wasn't what my intention was, I didn't mean, and they're going to give their version of events and attack your credibility and all those things, you might have a judge that just questions that it really happened that way, right? And so you may not get the order of protection even if you were the victim of abuse, and that's a horrible thing to hear, but you sort of have to be prepared for that sometimes. If it's a case that's on the fence, if you will, if it's maybe not something that's super easy to prove, I guess is what I'm trying to say, because again, abuse happens usually when there's nobody looking, behind closed doors. You don't usually have, you don't have like the cameras you might have in a public place in like a store or a restaurant or something. You're in your house usually when this is happening. It is going to be your testimony against their testimony, and if you have any corroboration to support your testimony, great, but a lot of times you don't. A lot of times there's not marks left on what's happening. I guess what I'm trying to say is some cases are easier to prove than others. That's just the reality of the situation, and if it's something that's on the fence, like you said, a judge might be like, I'm sorry, this is just too close. I've seen many judges be like, it sounds like maybe this did happen, but you don't have the evidence. You haven't proved your case, by a preponderance of the evidence.
Yeah, so, you haven't carried your burden.
You haven't carried your burden, exactly. And so just that is what I see sometimes. It's like, yes, this absolutely happened, and it absolutely is abuse, but is it something you could prove to a certain standard in court? Preponderance of the evidence, what does that mean? It means more likely than not that this happened. That's the standard for these orders of protection, but judges are human and they're different, and so more likely than not to me is probably different than more likely than not to Dean. And of course, yes, there's some parameters of, they have a lot of discretion. I mean, they're the ones hearing the facts, and like you said, they hear different cases every week of different levels of severity. So
and the crazy thing is, I'm sure you probably had cases like this where on paper this is sort of a weak order of protection, but for whatever reason you took the case, you went into court, and then the other side acted so ridiculous in court that the judges wanted to give order of protection. Yes. I saw, this is before the pandemic, I saw someone get tased in the courtroom and let out. He was surrounded, and he acted so recklessly and foolishly and violently that he was tased and let out, and then the judge just granted everybody an order of protection. And
100%. And so it goes both ways. Exactly. Sometimes we had this one. So I mentioned how sometimes child abuse can be very difficult to prove, right? Because you have a young victim and it's hard to show and they can't testify. There was one case we witnessed. It wasn't actually ours. I just witnessed it. But on paper, it didn't sound that bad. It sounded like this person was screaming at their child very badly. But again, the child was too young to testify about it. So it was just going to be his estranged wife testifying about it. Well, she had a camera in the baby's bedroom. It was like one of those baby monitor cameras. Apparently, you could save save the video audio. And with the video audio, you could see how this abuser was doing it. And he was in this very little child's face, just screaming at the child. The child was crying, and it was awful. I mean, to watch it and listen to it gave everyone, just make you sick. It was so bad when you saw it on this recording. And the judge even commented at the end of that hearing, she granted the order of protection, and she said that was some of the worst video I've seen. And again, he didn't lay his hands on this child. And if it was just the wife testifying about it, I don't think it would have gotten the order of protection. But with that camera from the baby's bedroom, you could see how bad it was and how abusive it was. And I know that's the exception to the rule, because right, we don't normally have cameras in our house. I mean, maybe nowadays there's some people have, but not everybody can afford that. Not everybody has cameras in their home to that level to be able to show exactly what happened. But on paper, not that strong. In reality, it was actually much stronger than it was on paper. So it goes both ways. And like I said, yes, it's preponderance of the evidence standard, and that is every judge is a little bit different in the way they hear these cases and what they find persuasive. So it's just something to talk through with someone if you're considering taking a case and you don't have, it depends on the evidence, it depends on the facts of every case. But
yeah, things are so situational.
Right.
That's why we can't always tell people, hey, don't file an order of protection based on that. Because nobody knows.
I was just going to say, and if anyone tells you that they can tell you what's going to happen 100%, they're lying to you, because they do not know. They do not know how the evidence is going to come out.
I try to give people the best guess,
Right. I think what it is it's here are the possible outcomes. Here are the possible outcomes. This is the best case scenario. This is the worst case scenario, and this is like something in the middle.
There's also a category, two different other categories, where you don't even have to know the other person in order to apply for or get an order of protection, and that is stalking. The first one's stalking. It's its own category. Again, this is in Tennessee. If you're outside of Tennessee listening to this podcast, your state probably has something similar. All states are different, but there's also a lot of similarity as well. I think stalking, I've gotten orders of protection based upon stalking, but they're often difficult to convince a judge. I've seen a lot of them not granted because for one reason or another. First of all, with stalking, it must be a pattern of behavior, and a person you must feel terrorized, frightened, intimidated, threatened, harassed, or molested. That's coming straight out of the statute. Terrorized, frightened, intimidated, threatened, harassed, or molested, and actually cause you to feel terrorized, frightened, intimidated, or threatened. So there's like a two-level thing going on there.
Right, the objective and the subjective. So it has to make a reasonable person feel that way, or would make a reasonable person feel that way, and it makes you feel that way.
Yeah, so I've been in court, and whether it's my case or cases I'm not trying but happen to be there, I've heard judges say, hey, you feel threatened or terrorized, harassed by this, but I don't really feel like you should have been.
Right, I don't think it's reasonable.
Yeah, I don't think it's reasonable. So the judge, it has to be reasonable to a judge. Mm-hmm. Not just you think it's unreasonable, this behavior, but the judge has to think of it that way as well.
I find that with stalking, you have as well, I know, been to specialized trainings on stalking for a couple hours here and there, and it's a whole lesson plan of its own. So I don't know that we can cover everything with stalking in a shorter amount of time, but right, it has to be 2 or more incidents. There's usually what they mean by pattern and this objective and subjective standard of making the victim feel this way. It is hard to prove. I think most people think of stalking as somebody following you around or not leaving you alone. But obviously when you read the definition and you look at some of the case law, that's not exactly what it means. It means a lot of things, and it can be a lot of things. It doesn't even have to be criminal behavior. It just has to be that it would make somebody feel this way. So one of the incidents can be non-criminal behavior, but obviously it still needs to meet the standard that it would make a reasonable person feel threatened, harassed, intimidated, frightened, molested, whatever it is, those categories. It would make a reasonable person feel that way, and it actually made you feel that way. But stalking can be more difficult. I would say what I have seen, I've even seen something called a stalking log, where if you have someone who is feeling like they're being stalked, where they start writing down the different incidents, because it's hard to keep track. If somebody's harassing you, and they're doing it probably in different ways, right? Maybe text messages, maybe calls, maybe showing up at your work, maybe following you, and how you can keep all those dates straight. But if you can write that down and make a log, it's just easier to report. Stalking is, in most states, I believe, a criminal offense as well. This victim might be reporting this to the police, or they might be filing for an order of protection, right? So more that they can explain with detail, the better.
And that stalking log, if it's done right, correctly, can get into evidence. As a extemporaneous writing, mm-hmm. written within, close to the time
right.
that the incident occurred. Because I try to stress that to people often. These stalking logs, that's a really good best practice to use. And if you are being stalked, to keep a log of what happened and when it happened, and try to write it as close in time to when the event actually occurred, if that makes any sense. Don't wait hours and hours and hours. And again, a judge can see that. That can be entered into evidence that this is what happened when it happened.
And so right, it is very hard to prove, but then you can do these things to try to make it stronger. The stalking log, if this person is calling you incessantly, take screenshots of your call log, things like that. If they're calling you from unknown numbers, obviously that can be difficult to show that it was the actual person, but just be ready to try to explain this to somebody else. And or what I would maybe also suggest is if this is a case where there was domestic violence and then now there's stalking, and then just, sometimes it's not independent. Of course, there are stalking alone cases, but sometimes it goes with domestic violence as well. And so just make sure that people know it can be both. It can be domestic violence and stalking. And when you look at the order protection statute, you could check both boxes. It's not like you can only check one. You can check both when there is a basis for both. But then also, let's say there's not domestic violence. This is not a person you know, or maybe you know them, but they're not an intimate partner. Maybe they're just, a coworker, a neighbor, an acquaintance who is sort of doing these things to you. If you can make out the stalking case, then you can file for an order of protection.
And you brought up a good point, is that these behaviors are often not criminal. I just read a news article about a professional football player, retired. His name's Aaron Donald. He played for the Rams, defensive tackle. He's very well known. He played at a very high level. He was stalked by a female who would do things like fly across the country and visit and see him, like at a public event or something. And she kept doing it over and over. I think this happened just in March of this year, 2025. She filed for divorce against him when they were never married. Just things like that. And whenever you tell a judge, context matters. Whenever you tell a judge something like that this person's been told to stop and they keep doing it and they're doing outrageous behavior relative to who they are to this person, if that makes any sense, that's when you can convince a judge that order of protection is necessary here.
Right. And I do think that's helpful. If it's a sort of situation where this person has maybe somehow gotten your phone number, your email address, and they're incessantly or continuing to give you unwanted contact by phone or email or social media, if you tell them to stop, if you ask them, I think that's helpful. So if you could show the court that you in some way, usually like a written way or a recorded way, that you inform them, like, please stop contacting me. I do not want you to contact me any further. And then that person continues to do so and you do not respond anymore, I think that's helpful. What we see sometimes is maybe somebody says that, like, leave me alone, stop contacting me, but then they proceed to later engage with the person. That can just make it harder to prove the stalking. So if you do ask them to stop and you can show that you asked them to stop and then you do not engage with them anymore, that is helpful to your stalking case for sure. I think that another fun little tidbit for stalking is the jurisdictional issue, because like you mentioned in that case you described, this was happening in different places. They were flying to different places to see them. But normally with like an abuse case, where the abuse happens, that county has jurisdiction over the case. Well, if it's stalking, it may happen in multiple places, right? It could even happen over the internet a bit, phone calls, people might be in different counties when it happens. When it's incidents have happened in different counties, then any of those counties might have jurisdiction over everything that happened in the stalking pattern. So if, I'm stalking you and I, followed you here in Sumner County, but then also down in Davidson County, I showed up when you were there for something, and then also in Williamson County, you can bring your case in Sumner County. And if you're explaining the entire course of conduct, and at least some of it happened in Sumner County, all of that can come up in the Sumner County case. It sort of is able to take all in. Or if it's happening over the phone, somebody's calling you, you don't know where they're calling you from, right? You're probably not going to have evidence of where they were physically when they're calling you or texting you. Where you are can have jurisdiction over that stalking fact pattern and over that stalking case. You, the victim.
Our next category, so we talked about abuse, we talked about stalking, and the third category is sexual contacts, unconsented sexual contact, which is sexual assault, rape. And the definition, this isn't, I'm going to sort of paraphrase the legal definition, is that you have been threatened or placed in fear of any form of rape, defined as sexual penetration with a weapon, victim. Could be a child, it could be a person with limited mental capacity. Maybe a weapon wasn't used, but there's some sort of form of intimidation to overcome your will to, I wouldn't say to consent to the act, but intimidation to do the act. Physical helplessness, I would say like maybe a drunken person situation or otherwise not able to consent. Sexual assault that might result in bodily injury, might occur as a result of fraud. I don't know if I'd have an example of that, but fraud might involve a threat of kidnapping, extortion, force of violence to be performed immediately or in the future. It might be a pastor, a doctor, or some sort of therapist as well.
I think the fraud fact pattern is usually like the doctor doing, something inappropriate and under the pretenses that it's a physical exam or something. But under the order protection statute, sexual assault is definitely covered as a form of abuse. It can come in, again, in both contexts, both the domestic violence context, it can happen in an intimate partner relationship, or under the statute, it also covers folks who do not fall in that category. So maybe this is a stranger. It could be a stranger. It could be an acquaintance, a neighbor, anyone really. The relationship does not matter for the order of protection if you are alleging sexual assault. And so that's an important just difference to note. So what I see a lot with the sexual assault cases here is just that if it's part of an intimate partner fact pattern, then it's sort of kind of similar to the cases we've discussed. It's going to be part of the DV case and you kind of have all the same considerations. When it's someone you don't have that history with, so not an intimate partner, I see a lot sort of in the dating context. Folks are maybe acquaintances or they met online and then they're getting together. The sexual assault happens, then often it's being reported to authorities. If they're filing for an order of protection, they're probably also reporting this to the police, and so there might be a criminal case and there might be an order of protection case as well. I just think that the important thing for folks to know when they have reported a sexual assault, which is such a hard thing to do, to begin with, we know that sexual assault is, I think studies have shown that it's highly underreported. It's the same as the other cases, same as domestic violence, very difficult to prove often because there's not witnesses. This is stuff that's usually happening when there's no one around. So there's no witnesses, there's usually no cameras, sometimes there's no marks. Sometimes sexual assault doesn't always leave bruising or physical injuries. It's highly underreported already. But if you're getting to that point, you're reporting this. You're reporting that you've been sexually assaulted. If there's a criminal case that goes with that, then I find often that clients who are referred to me for this don't even realize that it's two different cases because they have gone through this horrible experience. They've gotten to the point of reporting it, which is hard enough as it is. They report it to the police, and then the police take that report, get that arrest warrant, are also then taking them to either downtown to file an order of protection or to the Family Safety Center to file the order of protection. And they do that, but the client or the victim does not realize that this is two separate things. And so I just think that's one thing from the jump to realize that there's a criminal case for what happened, and there's also the civil order of protection that is a different matter. It's a civil matter ordering this person to stay away from you like we described. Just something to note, because when you have that criminal case pending as well, there are usually at least bond. Every state, every jurisdiction is different. I used to practice in New York, and in New York you actually automatically got an order of protection that went along with your criminal case. But here in Tennessee you don't automatically get an order of protection, but you do often get bond conditions that will order the defendant to leave you, to not contact you, to stay away from you, and if there's a violation of that condition, their bond could be revoked. That is what we see here in Tennessee, that if there's a criminal case going, there's usually bond conditions. And so it's important to know that, because this is where I see that it's just every situation is different and every victim and client needs to just think about what is important to them. If this is a stranger situation or a not intimate partner, someone who don't have to see them, you don't share children with them, there's no reason you ever need to see this person again, and you have the protection of the bond conditions, they just need to decide, do they also want this order of protection? Because the order of protection does give an added layer of protection. There's also, under the order of protection, the respondent's ordered, like, they can't have firearms and those things. But since this isn't a DV relationship, you're not going to ask for anything else. You're not asking for support or anything like that. It's just an order to stay away from you, and also the firearm provision, right? Which might be covered in those bond conditions. So that's sort of where the victim needs to decide, do I also need this order of protection or not? And everyone's different. They need to think about that, because it's two separate hearings. And then so what I just want the victim to understand is, under the criminal case, and I used to practice as a prosecutor in New York, I've never practiced in Tennessee, but I understand the process here as well. That victim can expect she's going to have to recount her sexual assault several times. Of course, when you report it to the police, then after it's reported to the police, there's a warrant issue, there's an arrest, the district attorney's office starts a case for that assault, that sexual assault. You're probably going to get interviewed by a district attorney who's preparing the case. You're then going to need to probably testify at a preliminary hearing. And sometimes there's ways to get around that with other evidence, but if there's not, you can expect to need to testify at a preliminary hearing. This will be presented to a grand jury at some point. It'll be bound over, and eventually that criminal case will go to trial, and you can expect, unless there's a plea offer that's accepted, that there'll be a trial at some point. Process can take years. I mean, it's a slow, criminal cases do not move quickly for many reasons, but certainly it can take a long time. That victim has to sort of be prepared for that if the criminal consequences are going to hopefully eventually come to that place of holding that abuser, that rapists accountable, right, in criminal court. So that's one case here. Then you have the civil order of protection. That is a very different case. As we have described, when you file that petition, it will be served on the the respondent / defendant as soon as they're able to find that person to serve them. And then you have 15 days to get that hearing completed. It will be scheduled within 15 days. Sometimes you can get a continuance for a week or so, but that's getting heard within the month for sure, usually. So then you have this victim of sexual assault who is already having to, go through the criminal case court process usually, now also has a hearing within 15 days of filing this petition. And that can be very difficult for them to go through, in addition to everything that's going on with the criminal case, and it's such a short turnaround time. And what I see happen a lot of times when there is this criminal case and this order of protection happening at the same time is that the perpetrator has a criminal defense attorney, because they're either going to have public defender or they're going to hire somebody. Well, that person they're knowledgeable on this. They know I can, in this civil order of protection, get a lot of discovery on this sexual assault case that I can use in the criminal case. So I could serve under order of protection. You can serve discovery. Here where I practice in Davidson, that has to happen in the circuit court. They don't do discovery if it's in general sessions, but if they want to do discovery, all they have to do is request to transfer the case to circuit court to then serve the victim with discovery. They can serve them with interrogatories, requests for production of documents. They can try to set up a deposition. They can do all of that if it's a civil case. They can do that to get discovery that they are not going to get from the criminal case, probably for many months, if not longer, right? So they'll do that to get discovery. I've seen it happen many times. Then, let's say, even if they don't do formal discovery, just at the hearing, they're getting discovery, because they're going to get that victim on the witness stand talking about it, being cross-examined about her sexual assault. I'm saying her, it could be him or her, their sexual assault. That testimony can be used later if they have a court reporter or if they record that hearing. Whatever is said at that hearing could be used later at the criminal trial to try to create doubt, to try to impeach the victim, to try to poke holes in their testimony. And the way that's done, even if the victim is completely being honest about every detail and telling their story, human nature tells us, we know from studies, that when you tell somebody something, a story or from your memory, you might tell it different when you're telling it to different people in different settings, different situations, different recall. Just maybe you might just remember it differently when you're telling it, or the way the questions are being asked. And so defense attorneys are very skilled in taking that testimony when you are under oath and on the record, and they're asking you all these very detailed questions at that civil hearing, and then taking those answers and trying to use them to cross-examine you during the criminal case, just creating doubt, right? Because in the criminal case, their goal is just reasonable doubt. It's a very high standard, what has to get proven in a criminal case, and that's their goal. We just got to create doubt, and I'm going to use this testimony to try to make it seem like the story's been inconsistent or something. I am not saying that is a reason not to go forward with your civil order of protection. I'm just highlighting that if you have a criminal case and you have a potential civil order of protection for sexual assault, and that's the basis, I just think you need to think about what's more important to you: holding this person criminally accountable for their actions, or getting this order of protection for up to 1 year that they're ordered to stay away from you, especially if there's bond conditions on the criminal case, because you have that protection in the criminal case. Criminal case might go on longer than 1 year, and so they're not the same. The bond conditions and the order of protection are not the same, but I just think it's something that a victim of sexual assault has gone through so much already. They just need to decide, do they want to go for both? If so, great, go for both. But just be aware of how that civil case can be, a defense attorney may use that as a way of getting discovery on what happened and try to use that in the criminal case. And so
there's a risk.
There's a risk.
There's a risk. It may not be may not be a big risk. It might be, small things matter. And if there's any slight difference, a skilled attorney that represents the respondent, the defendant, or whatever, the abuser, will be able to pick that apart and use that to the abuser's advantage. Do you want to risk that when you're already protected by bond conditions? I guess is the overall point here.
Right, and every victim is different, and every situation is different. Because maybe this person is your neighbor. Maybe you do need that order of protection because you're going to run into them, or their classmate at your school or something, or a coworker. Maybe this order of protection would very much protect you in a way that the bond conditions don't. And if so, yes, absolutely. But I know I've had cases where the perpetrator actually had no idea where the victim lived. Like, they had never been to her place. So everything I think had occurred at his place. I mean, there were just other ways to keep her safe, right? Safety planning, in addition to the bond conditions, would probably get it done because he didn't know where she lived and he didn't really have that much information about her. She chose not to go forward with the order of protection hearing, but for some people it might be worth to go for. It's just something I noticed, that victims of, when it's a sexual assault case, they're not always completely aware that it's two different cases. They think it's all one, and it's not always the case.
Sure, yeah, I'm sure. Just like in a lot of DV cases, it is a sort of a blur. In other words, an event happened and things could sort of jump up in your mind. I think that's the nature of having a traumatized brain.
Right, and maybe in some states, some jurisdictions, they would be all together. Like I said, in New York, where I practiced when I was a prosecutor, you did get an order of protection as a part of your criminal case, as long as the case was open. And then at the end, depending on what the plea was, you might get an order of protection at that point too, for a certain period of time, depending on the plea. But here it's different. It's just something that I don't think a layperson would 100% understand the difference. And it's just a good thing to think about when, maybe folks who are like sexual assault centers or family safety centers. I think it's an important thing to make clear to folks so that they just know that it's two different things. And because I've also had victims who were sort of like, well, I don't want to, of sexual assault only with the order. I don't want them, I want to hold them accountable for this, and I don't want to let them off the hook. And of course not. But the question is, the order of protection does one thing, the criminal case does another, right? So which way is it that you want to hold them accountable? Do you want to hold them accountable criminally, or is that your focus, or do you want this order of protection that says that they have to stay completely away from you? You might want both, I don't know, but it just means something different to everybody. Holding somebody accountable for their actions and the abuse and the sexual assault, it means something different to everybody. And I just think that when it comes to an order of protection, I just want to make sure that they understand that this is an order of protection. They're going to be ordered to stay away from you. This is a criminal case where they might be ordered to go to jail and lose their liberty for what they did to you. That just know that those are different cases, not the same, at least here in our jurisdictions.
I have not had that many sexual assault cases in my career at legal aid or even beyond, but I do understand, have been trained in best practice. Maybe that's for the reason you brought up, is it's either underreported, or maybe people feel protected under bond conditions with people who have been involved in these kind of cases. But there are, I guess, what might be considered best practices from a survivor standpoint, and that is that anything involving rape, sexual assault should be reported as soon as possible, because if there's a gap in time, that is something that can be picked on.
Right.
Among other reasons.
Yes, of course, there's many reasons why there's sometimes a delay in reporting, and you can still report it. You just got to be kind of prepared to explain why there was a delay in reporting. But if you can report it right away, obviously there's, depending on the type of sexual assault, but especially just if you think of a rape case, I think most people have heard of like a rape kit, which is if you report a rape that has recently happened to police, they can take you to the hospital, and at the hospital they can do, if there were, potentially bodily fluid that could be recovered, or even, under your nails, things like that, they can kind of do certain things to try to recover evidence of the perpetrator's DNA on your body. If that is done, what I will say is those takes a while to get. The rape kits take a while to get processed. So for an order of protection case, you're probably not going to have those results. Like I said, 15 days, right? We're not going to have the results. But for a criminal case, they wouldn't be taking it to trial until they had the results of that rape kit. And the rape kit might show that, there's semen on the victim's body that matches the DNA of the defendant, or there's skin under her nails that DNA matches, I'm saying her, but him or her matches the defendant's DNA. Things like that you might have in a criminal case, because again, a criminal case takes many, many months, if not a couple years, to go to trial, versus this order of protection that happens in 2 weeks after it's filed. Going to have that for the order of protection case. But that's also just a reason to report as soon as possible, because if you do have that person's DNA on you, that is very strong evidence to show that is, the identity is not an issue. Because in a rape case where it's not intimate partner rape, and it's identifying who the perpetrator is can be one of the main issues in a criminal case. So
I think there maybe, perhaps, I'm speaking about this without any background research whatsoever, but perhaps sexual assault is underreported in some respects because married people don't understand that there is something called spousal rape. Right. That is a thing. Right.
So in the DV context, sexual assault is absolutely abuse as well, and marital rape is rape. And I think that in some cultures, and even in just America for many years, it probably wasn't really looked at that way. Just the way domestic violence wasn't really looked at as a crime. It was more looked at like a marital issue or marital problem, not a crime. But it absolutely is a crime, and it's a crime. I do think most courts acknowledge that these days. I don't know, in the courts I practice in front of, I think the judges understand that marital rape absolutely happens, and that it is a problem, and that is a crime, and it's difficult to prove in court, just like it is when they're strangers, because usually it's not happening with witnesses, and it's happening behind closed doors. But if someone is testifying about it credibly, that you can absolutely, judges will grant an order of protection on those grounds if they find the wife to be credible, same wife obviously, but just what we typically see. But I think that it's going to be the same defenses that you see in a typical rape case, where either they're going to say that there was consent. You have to just be ready to argue why there wasn't consent on that particular occasion. One thing I've seen that is difficult is if there was sexual assault in a marriage and then it's not reported right away, and then subsequently the relationship either continues or there is consensual contact after that. I think that sometimes the judges are like, well, I mean, it's harder to prove, right? It's just harder to prove if it's not reported right away. And I'm not saying it's not possible, but it's just harder to prove in a marital context if it's not reported at least somewhat soon after it happens, because there's this sexual assault and it's not reported for a year. The judge it's going to be harder to prove to the judge that this happened. But if there is something more recent that happens, that finally is the tipping point, and the victim can say, like, this has been happening for years, but like this last time this happened and I just couldn't take it anymore, and that's why I've reported. I think that is the kind of explanation that a judge needs to understand that, like, okay, you finally reached your breaking point and why, so that I can understand why you didn't report this sooner.
My experience with sexual assault in marriages is usually along the context of talking to clients, and we're going through their problems in their relationship and so forth. And then if you talk about unwanted, unconsented sexual contact, and they say, oh yeah, and it's almost like it's just what I have to put up with. That is even the main problem. The most recent problem, the worst problem is sort of a broken eye socket or something like that. But it's just something that I think a lot of spouses, at least in my world, seem like they just had to put up with just to go along to get along. In the same way, perhaps, that stalking is like that. I think some people, maybe some judges say, well, there's no stalking within a marriage, but there is. It's people can be monitored. A spouse can show up at the other spouse's employment to sabotage their employment efforts, or because they think they're jealous. I mean, not because they think they're jealous, because they are jealous, and they think they're cheating on them, or driving by their employer, or all these other things that we already know about that related to stalking. So in that way, I kind of see those two problems as maybe similar, in the sense that it's ongoing. That's not even the worst thing that's happening in marriage.
I think that it is similar in that you can absolutely stalk your spouse, you can absolutely sexually assault your spouse. It might just be a little harder to prove in court, because you have this extra layer of showing too that, at least with stalking, that there was no legitimate purpose. Because while you can stalk your spouse is probably going to come in and say they had some legitimate reason, like, oh, I was just, that's my car. I wanted to, I tracked my car for whatever reason. Or that our phones are joined, the Find My Phone, whatever, just so we can, in case we lose our phones, we can find a phone. Or I was trying to find my kids. I couldn't find the children. If one spouse leaves and has the children and other spouse calls or tries to find them incessantly, they'll claim, oh, I was just trying to find my kids. So with stalking, I just think it's a little harder to prove when it is your spouse, because you're just going to have to be ready for those defenses that this person had a legitimate purpose for the contact. With the sexual assault, I think, like you said, I think culturally, for some, I used to work in Queens, New York. It was one of the most diverse counties in the world, probably. You had so many different folks from different countries represented in that county, and even here in Nashville, it's a fairly diverse county, especially here in Tennessee. Lots of folks from different cultures where marital rape is completely acceptable in their culture. They've even maybe talked to their religious leaders of their church and have been told that it's just part of the marriage, or you got to work on improving this, or whatever, in their culture and their religion, whatever it may be. For that reason, I think it's often not reported right away. Like you said, either the spouse just thinks this is something we got to work on, or our culture won't let me get divorced, or something like that. So they just suffer through it and they don't report it right away. And so then when they do reach a breaking point and they're telling us about this, or they're filing for an order of protection or a divorce and they're talking about it, I think it's relevant and it's important, and it can be proven. It just might be, you just have to understand that in the court, if it happened farther in the past, it's just going to be harder to prove, right?
Sure.
So the sooner it can be reported, the better in terms of that.
Yeah, judges are like, why did you wait?
Right. And there's a million reasons why they waited, probably, and really understandable reasons, but just sexual assault is already a difficult thing to prove in many contexts and relationships, but if it's marital, it might be harder to prove. And so just be aware of that and think about ways that you can corroborate the case, or be prepared to explain to the judge why you waited and what the reasons were.
Once again, I'd like to thank Rebecca Toca for coming to the studio today to Talk TV. She and I will continue our discussion on orders of protection in the next episode, including how to prepare for an order of protection, how to testify, and then we'll return to children's issues in the order of protection context. That's next time on Talking DV. Thank you for listening to Talking DV, a podcast that focuses on providing you with practical information on how to leave an abusive relationship. I'm your host, Dean Hinton, encouraging you to seek legal counsel for your specific case. If you cannot afford an attorney, contact your local legal aid office. Many legal aid offices often offer free legal clinics where you can speak to an attorney face-to-face about your specific legal problem. There's no reason to give up hope.